Welcome to Bodacious Estate Conversations, the podcast where we skip the polite small talk and get straight to the real story about handling a loved one's property. From unexpected challenges to the messy emotions nobody warns you about, I bring you unfiltered stories, practical advice, and clever shortcuts from people who've been there and the professionals who know the way. If you want honest answers, bold strategies, and the confidence to take control, you're in the right place. Here is your host, Casey King.
Thanks for tuning in. On today's episode of Bodacious Estate Conversations, I'm excited to chat with someone who spent more than 3 decades helping families, investors, and businesses navigate the complex world of real estate. Our guest is a senior partner and former managing partner at MPL Law Firm, where he concentrates his practice in real estate and business law, guiding clients through everything from residential and commercial transactions to zoning, tax assessments, and corporate matters. When he's not helping clients or managing his team, he's enjoying life in Helm with his wife, Jenna, and their 3 children. Let's give a warm welcome to Bradley Leber. I'm so thrilled to have you on Bodacious Estate Conversations, Brad.
Well, I'm so thrilled to be here. Thank you for the introduction.
It's going to be awesome. So I know we've got a lot of good content coming out today. So we're going to be talking about one of the most important but also misunderstood aspects of real estate, the legal side. From property titles and contracts to closing, there's a lot that can go wrong if you're not protected. So stick around until the end because Brad's my dog's coming to visit. So Brad's going to share one of the legal mistakes he sees time and time again with home sellers that could end up costing you thousands. So, I mean, Brad, let's just dig right into it. With so many moving parts in real estate transactions, from titles to contracts, what's one of the most common legal issues you see come up, especially when someone's preparing to sell or settle an estate property?
Well, this may sound silly in a way, but the most common thing that we see is that sellers who are family members of deceased relatives often don't even understand that they need to have an estate opened and otherwise be appointed by the court to transact business for that deceased relative's estate. Time and time again, we're being brought contracts where a child of a deceased parent has signed to sell a property, but has had no authority granted to that person by the court to do so. And so when a property is titled in the name of someone that has died, generally speaking, the only way to transfer that property to a buyer is for the court to empower someone, either an executor named in the deceased person's will or an administrator appointed by the court for someone that didn't have a will, to transact business for that estate and clean that estate up by selling assets, accumulating the funds, and paying the required taxes. Without that appointment from the court, you have no authority to sell the real estate unless you were already on the deed with your parent. And of course, that's not a very common situation. So most people have to be appointed by the court. And we see that very frequently people aren't aware of that requirement. So as I said, over and over again, we're being presented with contracts that are very innocently signed by someone who believes they are authorized to sell, but in fact, at that stage cannot sell. And so then you have to backtrack and you have to get that person appointed as an executor, which takes some time and a little bit of money. And it slows the process down dramatically. Usually it's fixable just by going back and starting that process from scratch. But if someone was on a tight acquisition time frame, that can throw a real wrench in the process.
Yeah, I see that a lot too. I just had one about 2 months ago where the daughter, her dad passed away a couple years ago, didn't bother to set up an estate, and she said, again, very innocently, "Well, he doesn't have an estate, but we're selling a plot of land, so there is an estate there." But she didn't see it that way, and she didn't know that she had to do that. And another thing she said that was confusing to her was, "Well, I sold his truck." Without going through this process. So can you explain the difference between selling a vehicle and selling real estate?
Yes, in most instances, you may sell the deceased parent's vehicle simply by taking a death certificate and some other proofs to a vehicle notary with your buyer and conducting the transfer that way. It is different, however, to move real estate out of a recorded deed as would be required by law. So there are no shortcuts to the movement of real estate that's deeded in the name of the deceased person. You have to have authority from the court to do so, and you have to deed the property out. So
And that does take time. If you had to put like a I know each county is probably different with this, but if you could put like a timestamp or a timeline on it, how long do you think it takes to set up, an estate?
well, in the age of post-COVID remote meetings, it has picked up a little bit. Now it's very routine with many of the counties, some of the smaller counties excluded, of course. But in York, where I do most of my work, we do Zoom probate petition presentations. So you can prepare the petition, which doesn't take much time. It's just 2 pages. You attach the will, maybe a death certificate, some other things that are required by the court. You submit them to the court. They schedule the Zoom hearing, and a lot of times the client who is the executor doesn't even appear in my office. They just sit in their kitchen, attend by Zoom. I sit in my office, attend by Zoom. And then the representative from the Register of Wills office initiates the Zoom meeting, and we go through the probate petition together. At that point, the executor is sworn in, uh, then the meeting is closed, and the representative from the registrar's office instructs us to deliver the original documents to them, which we do. And then that's it. The appointment is complete, and then they can transact business. I would say overall, that process can be accomplished in as little as a week to 10 days.
Okay, that's not so bad. I was thinking
It can extend sometimes longer than that, but I think a week to 10 days is a reasonable expectation.
nice, okay. Do you do, so I know the majority of your work is done here in York County. Do you do other, neighboring counties? If you do, do they have similar timelines?
We do. MPL is a regional firm, so we cover Lancaster, Dauphin, Cumberland, Adams, Franklin, maybe even get over to Berks and Lebanon every now and then. And yes, for the most part, they tend to be within that same realm. Adams County does, at least to my knowledge, most recently, still requires in person presentation. So that can slow it down because now you're trying to schedule an appointment among several people to go to Gettysburg. But in general, yes, that's a fairly consistent time frame across the board here.
That makes sense. So with the timeline then, so once the estate's set up and the executor is, well, appointed being the well, we should talk about that process. So how does somebody, become an executor and get appointed through the court?
There will either be a will or there won't be a will. But in either situation, you have to apply for that authorization through a petition to probate that you present to the Register of Wills. If there's a will, you're petitioning to have that will accepted by the court as authentic. And there are requirements that are statutorily mandated in order to meet that test. Generally speaking, the will has to be signed in ink. It can't be a photocopy. It needs to be witnessed by two disinterested parties, and it needs to be notarized. And as long as it meets all of the requirements of the statute, then the court will typically accept it or probate it and then grant that executor named in the will the authority to conduct business. It does that through a piece of paper that are called letters testamentary, or letters that are derived from a will. And it's a little certificate with a little gold embossed seal that tells the world that you've been appointed by the executor and can now conduct business. If there isn't a will, then there's a slight variation to the petition where you disclose to the court that no will exists, but that you're a qualified relative or heir who, under the laws of Pennsylvania, is entitled to serve as an administrator of the estate, and that you're requesting the court to appoint you in that position. And as long as you're a next of kin or other qualified relative and you're certifying that no will exists, and there are no superior relatives who are objecting to your appointment, then the court will grant you that same authority, but those are called letters of administration. And either way, you get the certificate with the gold seal, and that is what empowers you to then sell the real estate and do all the other things that are required to be done to complete the estate administration.
Yeah. Do you ever get conflict with that, or is there ever, somebody that says, I need to handle, my brother's estate or my parents' estate, and then another family member, comes forward and says, "I don't think you should be that person." Does that ever happen?
We have seen that. It's not quite as frequent as you might think it is in today's world, but yes, we have a fairly high volume estate practice here. I'm not necessarily a part of that. There's within MPL a 5 or 6 attorney estate administration department that handles most of that work. I tend to touch it as part of the real estate process. But for sure, we have seen family conflicts where certain family members object to the appointment of another family member as administrator, and then that has to get sorted out. We either work out a deal among the family members and then present a petition that everyone agrees to, or you have to ask the court to decide who should serve. And you do that through the petition process as well. But happily, that's not a very frequent occurrence. And what it speaks to, honestly, is the very important notion that everyone should have a will. Once you've reached adulthood and you start owning assets, especially real estate, it's time for you to have a will so that you don't leave these questions unanswered upon your passing and tempt your family members to argue about it. Your will will spell out very clearly what should and must happen in order to administer your estate, answering therefore all the questions that would otherwise be left to your relatives to figure out for their own and potentially cause reason for argument.
Is there so if a property is owned by the deceased, and it's owned free and clear, there's no liens against it or anything, does it still have to be sold? Like, what would be reasons that a real estate would have to be sold versus whether it could be gifted?
Well, the will spell out what's to happen, and oftentimes that is what's in a will is that they're leaving the real estate to their children or a child or whomever. And if that's the case, then that's what has to happen. The real estate then passes down to the designated beneficiary. But if there is no specific provision made to dispose of the real estate, then part and parcel of administration is converting assets, including the real estate, into cash so that all required inheritance tax can be paid, and so that the value of the estate, thus converted to cash, can be handed out to the children, grandchildren, or whomever. It doesn't necessarily mean that the house or the real estate needs to be sold in every instance because maybe the family members reach an agreement that Sister Lisa is going to get the house, and that will count against her share of the inheritance. And the other brothers and sisters will get cash instead if there are enough cash assets to fund that. But as a general rule, yes, the real estate's going to be sold. And we see that in the large majority of estates.
Yep, that makes sense. So going through the process, we have the authority to sell the property as the executor. We set up the estate itself. Now it's time to prep the property for sale and get it sold. What are some challenges that you see those clients face?
In preparing it for sale,
Yeah, anything leading up to the sale.
well, I think for the most part, the big challenge that families face is getting that house emptied of personal belongings and cleaned up to be presentable for sale. Obviously, in estate situations, one of the most common sale mechanisms is public auction. And so a lot of times what you'll see is that the public auction is the method by which the house is cleaned out. So you have the sale, you sell the furnishings, you sell a lot of the belongings, and as those items are sold during the auction, the buyers simply take the things away. They buy the dining room set and they take the dining room set out of the house. They buy the couch and they take the couch out of the house. But there are items oftentimes and usually items where the family has elected that those items won't be sold. And so you have to coordinate with the surviving family members to allocate those items to whoever is going to receive them and get them out of the house in advance of the sale of the real estate so that those items aren't mistaken for pieces that are to be sold.
So, Brad, when we started, we told folks that if they stuck around to the end, that you would give them a little tidbit of what not to do. I, I should say on the legal aspects of selling a home. So what's the common mistake that you see, sellers make when executors or the appointed power of attorney could potentially make when selling that property?
Well, the mistake that we're seeing raise its head over and over again, and I'm talking several times a month on average, is a failure to properly disclose known defects in the real estate through the required seller's disclosure statement. So, in Pennsylvania, there is a statute that requires all sellers of residential real estate to disclose to a buyer all of the defects that the seller knows about the property, from flaws in the roof, foundational issues, water infiltration, plumbing problems, electrical problems, anything that would be considered a material defect to most buyers that require repair or other attention, or might require repair or attention in the near future. Those kinds of defects are all required to be disclosed to a buyer in order for that transaction to proceed. And if the seller fails to comply with that obligation to disclose, then the buyer has a claim against the seller post closing for the cost of making that defect right. And so there are some vagaries in the statute that tend to make people believe it is a warranty. So a lot of buyers believe once they've moved into a house and then discover that things aren't exactly the way they hoped, they think that that automatically empowers them to go back to a seller and sue for the cost of making that error correct. And the best way to avoid that is to disclose everything you know. Even if you think it's the most minor item of very little consequence, disclose it, and you can hopefully avoid that post-closing claim. In the estate context, the mistake that we see is that there is a block in the seller's disclosure statement that counts as something of a waiver, where executors or administrators or trustees or people who are serving as power of attorney can indicate on the seller's disclosure statement that they're excused from making a disclosure because they're only an executor or an administrator, and therefore they're not attributed with the same level of knowledge as an owner occupant might be. However, the pitfall is that many executors and administrators are children of the owner, the deceased owner. And as the child of the deceased owner, they have been in the house many, many times, and have, through that familiarity, become aware of defects. And sometimes they've become aware of defects because their parents told them about it, or they heard the story of, oh my gosh, the roof has been leaking for weeks and dad just won't take care of it. They've come across that knowledge through some mechanism. And once you have actual knowledge of the defect and you've become the seller, and you've become the seller because you're the executor of the estate selling the property, you're required to disclose what you know. So you can't hide behind that executor's cloak when you actually know about a defect. And here we're seeing claims very frequently, almost disturbingly frequently, that raise that issue that, hey, you didn't tell me about it. Now I've got the problem I have to fix. It's going to cost me thousands of dollars. I'm coming to you to pay for it. And so if there's one thing that I think your audience should take away from today, aside from understanding that they need to be appointed by the court in order to sell the real estate, is to be sure they're being as thorough as possible in disclosing known defects in the real estate so that they don't have a problem down the road after closing once they believe they've wrapped up the process and we're all done. And then here you go, 6 months later, you're being sued because someone thinks you didn't disclose what you knew.
Yeah, I think that's a really, really good tip. So another one that I commonly see that people aren't aware of are the taxes, the inheritance tax that comes out of the proceeds. So can you talk a little bit about in Pennsylvania what three levels of taxes we have on for inheritance tax?
The first thing to understand is that spouses don't pay any inheritance tax. So the spousal rate is 0%. So if you have a husband that dies and the surviving wife wants to sell the real estate, she's not paying any tax on that transfer out to her. However, everyone else pays tax and it escalates from 4.5% for lineal descendants to 6% for siblings and collateral relatives, and out to 12 and 15% for friends and distant cousins and all of that. And generally speaking, that tax constitutes a lien against all assets of the estate, including the house. And in order to sell that house, you're going to need to escrow a certain amount to cover that tax, which will be held by the title company until the estate representative is prepared to file the inheritance tax return, at which point that escrow money will be released to pay the tax. And most title companies will look at the estate, see who's been disclosed as inheritors, and come up with an estimate of the tax based on the information presented, and then ask for that to be held in escrow. In fact, not ask for it, but demand that it be held in escrow at closing until the tax return is ready for filing. So executors need to be aware that they're not going to get all of the money at closing. A portion of it is going to be held back to cover the eventual inheritance tax that must be paid.
Right. Yeah, I think that's always a shocker when I talk to my clients about what their potential proceeds are going to be. They're like, "Wait, what's this big chunk here that you have coming out?" And I'm like, "Oh, that's Pennsylvania inheritance tax."
Yeah, it can come to a surprise, especially to a seller who has been unrepresented in the process. They're finding out all of these things brand new as they come up. So it is advisable, and I don't mean this to be a self-serving advertisement for lawyers, but in the context of the death of a relative who you're going to handle the estate for, I think it's almost always advisable that you have legal counsel. It's a trap for the unwary to think that you, as a layperson, can easily and competently navigate the estate administration process without bumping into a few errors or hurdles. So it's best to just have professional advice on that level so that you're not being surprised and you're not setting yourself up for problems post closing that you didn't anticipate.
Yeah, that's good stuff. So, before you became an attorney, were you always from York County? Where did you grow up?
Yes, I was born and raised in Hellam, which is out on the eastern end of the county. It's Eastern York School District, the Hellam Wrightsville area there, where the bridge to Columbia is. That's where I grew up. I still live out that way today. It's a beautiful part of the county, very rural, very agricultural, and we just love it out that way. Um, and frankly, very convenient to York and Lancaster and Harrisburg as well. So you get the best of both worlds. But yeah, and I'm the solicitor of Hellam Township, so I get to be sort of the legal advisor for my hometown, which is neat because then I'm constantly in the know with respect to things that are going on in my community, and I love that. I do that at a reduced cost just because I love being a part of that process. Yeah, born and raised and still live in Hellam, Pennsylvania.
I love it. So, things you do on your spare time is legal counsel for your hometown. I love it. So, when did you become aware that you wanted to proceed with law? Like, when did you know you won't be an attorney?
Well, in high school, I was very science oriented, especially biology. And I had a very, very wonderful biology and advanced biology teacher that I became very fond of. And he became a role model to me. And so as I was getting through high school and planning to go to college, my thinking originally was I wanted to be a teacher. I wanted to be him. So I wanted to follow in his footsteps and be a teacher. And this was in the mid 80s, so 1986, 87. And as I was going through my first year or year and a half of college, it started to weigh on me that maybe my passion wasn't in the sciences the way I thought it was when I was younger. I started to gravitate more towards politics and business issues and economic issues. We were in the middle of the 80s boom, the Reagan era 80s boom, and economic growth and business growth and all those things were the hot topics of discussion among the younger class. And as that developed in my mind, it became apparent that I was going to get exposure to all those things through a legal career. And as I thought through it, I thought, well, there's 3 extra years of education and all that added expense. But I conferred with college counselors and talked it through and ultimately decided about, I guess it was the end of my sophomore year, that I was going to go to law school. And so the rest of my college education was spent gearing up for that through what used to be a pre-law major that you could elect. So they put you in English classes and business classes and accounting classes and things like that to prepare you for all the things that you're going to see in law school. And then I did very well on the pre-entrance exams for law school and was able to select Dickinson, which has been and certainly was back then the unofficial state law school of Pennsylvania. So anyone that thought that they would be practicing in PA generally wanted to go to Dickinson in order to have that specialized education. And so that's where I went, graduated from there. My first year in law school, I wanted to explore internships. So I sent letters out to all the York County firms and I got a hit and did a summer clerkship there. And that firm eventually became what is now MPL. So my entire law career has been spent with MPL and the firm that was the precursor to MPL. So yeah, it's 35 years now.
And you never look back.
Yeah.
Yeah. So what do you like to do in your spare time? I mean, you're a family man, you've got a wife and kids. What do you guys do to stay active?
Well, I got a late start with having a family. I didn't start having kids until my 40s. And so my kids are only 14, 12, and 11 now. And if you have any knowledge of what that's like, that's the active time. So all my kids participate in sports and other activities. And so we're constantly on the move, whether it's baseball, basketball, piano, horseback riding, whatever it is. We generally have something to do every night of the week, and that's what keeps us busy. And I wouldn't have it any other way. It's a lot of fun, and it keeps me young. There's nothing better for improving your spirits than throwing 2 hours of batting practice to 13 and 14-year-olds who want to kill you with a line drive up the middle. It's a lot of fun.
Yeah, that sounds fun. I don't miss the teenage years. So I had the opposite parenting experience. I got started in my early 20s. So now that I'm in my 40s, I'm like, we're being
Graduated.
yes, I've graduated to an empty house. So my joy of life is taking a different role where I get to drink wine every night and
Right. Well, I'm not saying I can't do that, but but yeah, we have lots to do, and I can foresee another 5 or 6 years of being that busy. But I also see down the road being in your position. But of course, I'll be in my 60s at that point.
yeah, it's a lot to look forward to. Yeah, we just sent my oldest bonus kid to college this past summer. We got him set up at Auburn, Alabama.
Oh, fun. Yeah.
Yeah, so it's a nice transition.
A tiger, right? Aren't Auburn's the Tigers, I think.
Yeah, it's interesting. So their mascot is a tiger, but then they have a war eagle, which it's not a good story, and I'm gonna butcher it. But there was a teacher that had an eagle that was in a war and it couldn't fly anymore, so he just kind of like kept it as a pet, and they called it the war eagle, but it couldn't fly, so it like sat on his shoulder or something. And they were at a football game and their team was losing and everybody's, their spirits were kind of down, and all of a sudden the war eagle got up and flew and like just kind of went all around the stadium, which was amazing, and it got everybody fired up and their spirits were, all riled up. But it was a tragic thing because he didn't fly, so he didn't know how to land, and he crash landed and died. And terrible story, but that's the War Eagle. So they kind of have like, I think that's their unofficial mascot, but the official mascot is the tiger, yeah.
Yeah, I've always wondered about these teams that use African or Indian animals, Asian animals as their mascot. We don't have many tigers in the United States South, but hey, whatever. Being an Eastern York person, our mascot is the Golden Knight, and you don't see many of those out that way either. So
Oh my gosh. Okay. So this has been amazing. Thank you so much for coming on. So if somebody, wanted to get a hold of you or just somebody at the firm to help, have counsel to go over contracts or how to set up an estate, where would they go? Who would they call?
they can log on to our website, which is mpl-law.com. And it's pretty user friendly. You can find me on there pretty easily by clicking on the attorney's link. And then there's a link to email me. If they want to email me directly, I love email. I respond to it all the time. I'm looking at it far too often, if you ask my wife. But that's BLEBER, B Leber, at mpl-law.com. Or you can do it the old fashioned way and give us a call at 717-845-1524. But yeah, we're always happy to help. I'm always taking questions from people who may or may not become clients just because I like to help and offer up tidbits whenever I can. But yeah, reach out if you'd like. We're always available to help.
Uh, I love that, and I can attest to 2 of those things. You respond to emails very quickly. Every time I've ever sent you a question, you've always replied within the day, and, which is not typical, I found for a lot of attorneys. So, you do very good with your management there of your emails, and also very helpful. Whenever I've had a question, you've never hesitated to give me, guidance, so I appreciate that.
And I appreciate helping.
Yeah. All right. Well, thank you so much, Brad. I'm sure people are going to get a lot out of this with the tips that you gave them. So that wraps up another episode of Bodacious Estate Conversations. Thanks for listening, and we'll be back with more great stories and tips soon. Bye.
Take care.
Bodacious Estate Conversations isn't just chatter, it's about learning, taking action, and finding solutions that actually work. If today's episode resonated, share your thoughts, subscribe, leave a review, and pass it along to someone who could use a hand. More stories, smart strategies, and practical guidance are coming in the next episode. Don't miss it.